Fantastic. Well, welcome back, everyone, to the fifth session of our series, our Lenten series on an exploration into death and dying. And today we have guests with us who have been with us several times already. This is Matt and his wife, Kelly, right behind. And this is a family business. Matt Miley and his wife have a practice in Windsor, and they have been attending the series. And today we're focusing on legal aspects that surround our deaths. Just looking forward one more week, our sixth session will cover church funeral plans, alternative burials, and our remains, and then we'll have a wrap up. So that's next Sunday. No homework for next Sunday that I'm aware of. All right. So we'll begin our session today with a practice, and hope you brought your linking item.
May I say one word?
Yes.
The lawyer brought one piece of paper. John said, "Oh, of course we get stuff from lawyer. One sheet, fewer than any of the other sessions."
You know, I'm an estate planner, and I wouldn't be leaving much of a legacy if I used all the trees.
Okay, Alex.
So our just brief opening exercise is to turn in groups of 2 or 3, and those on Zoom just kind of chat amongst yourselves. And if you brought your linking object, share just really briefly what it is, who it reminds you of. If you didn't bring it, that's okay. Think of something that you might have wanted to bring, and then see if you can name what that thing represents to you, or maybe what you channel when you with you. So these earrings were my mom's, and so I kind of channel her steadfastness. And this scarf was my grandma's, so I channel her feeling fabulous, her glamour. So groups of 2 or 3, and we'll wrap it back in about 3 minutes, so real brief.
This is the homily, is that the right word? Gotta get-
So the, Alex just asked Zoom people to share their stories.
One word.
Just really briefly.
Very briefly.
One word, yeah.
Your maybe your item and the word that comes to mind when you think about it. Really briefly. Just a couple, 2 or 3 words.
Dog lover.
I thought you wanted to be part of this.
There might be one.
Amy said dog tags, and the word is service.
Lyle says, Felicia's people's artwork. Words are creativity and motivation. And Jana, beloved aunt's pin. Brought it with her. There it is, in this picture right here.
Taking it on the Camino.
Oh wow. So cool.
And for me, the what was the priest that married Rosanna and I have a photo of that woman. So I think of her whenever I look at the photo. Carol Ford says, I wear my late husband's wedding ring as a reminder of his unconditional love. Still.
I just have a couple things from my grandparents that keep me inspired about spirituality and creativity.
Joe wearing her mother's November birthstone ring reminds her of love and compassion for others. And right over here.
Okay. Thank you. Thanks those on Zoom. A couple people from the room want to share just real briefly your item and what it represents. Yeah.
My late husband was a really brilliant, hardworking trial lawyer, fellow of the American College of Trial Lawyers, a big prestigious honor. And he made little toys, and he made hundreds of these toys that he just found a balance in life, and it gave him real joy. And when he died, we had a plastic tub, and there were oh, 10,000 little wheels in those of every size, but he stamped, it's attorney at toys. And they're right beside his picture.
Maybe one more?
This necklace was given to my grandmother, who was born in 1878, by her aunt and uncle. And this is her aunt and uncle's picture. And my aunt teased on it. It was here. And my grandmother gave it to my mother, and my mother gave it to me, and it reminds me of strong women.
You all, we know there are a lot more stories where those came from, so hopefully those can continue past our hour. But we'll turn it over to Matt.
All right. Well, thank you very much. Again, I'm Matt Miley, and we office in Windsor. And I am an estate planning attorney. I'm also do some things with elder law, Medicaid planning, things like that. So quite a lot of items that I could talk on, but I tried to keep it down to 30 minutes or less to be able to answer some questions and things like that. So I got a handout that I've given to everybody, and that's kind of got a couple goals there to give you some things to look at. Also to have a way to define what I'm going to be talking about and kind of limit the scope. But also, if you have questions on anything that I don't go over enough for your satisfaction, which could be quite a bit, go ahead and circle that. Maybe write a little bit of notes there. And if you want to email us after this to get some more information on that, feel free to do that, because there's no way I can cover the entire gambit of the legal aspects of being incapacitated and going through death. So if you look at number one there, the first thing that I'm talking about here with goals of estate planning, at least in our office, it is that I want to control what I have all my life as long as I am able, then leave what I want to whom I want, the way I want, when I want, at the least possible costs and fees and taxes. So if we can kind of work with that working definition, that will kind of give a scope of what I'm going to be talking to you about today. But also it allows us to have a working definition that you can use with anybody that you want to do. So I think it's pretty good. And then our firm is pretty client centric. So I try to remember that God gave me 2 ears and 1 mouth, and use that in proportion. And I try to listen to my clients and see what they want to do and what they want to talk about and hear about their goals and aspirations when we're designing a plan for them. Because after all, designing an estate plan is kind of like writing the last chapter of your life. If you want to be remembered as being generous, and you're currently not generous, we can write that last chapter, but we better start filling in the other chapters before you get there. So it is a lifetime process. In our office, we feel that we need to work with you as a family. And we believe that once you sign the documents, the relationship starts, and not when you get the documents, not as a transaction. And that is because estate planning, death and dying tend to change every year. Your family situations change. How they do things in Denver may change, and how they do things in Washington, D.C. may change as well. And a perfectly good will that you got while you were in service for our country when you were single may not work now that you have a wife and 3 kids, or a spouse and 3 kids, because since those people aren't mentioned in that will, the first thing the judge has to decide is whether you meant to disinherit them or not. So sometimes it's even better not having the old plan. So I encourage you that once you do have a plan, to just don't leave it in your safe deposit box. I mean, get it out, look at it, and make sure that you keep it up to date so it works when you need it, because you never know when the pickle truck's going to come hit you. So the top 8, number 2 there, the top 8 goals that most people have for their estate plan when they come into our office, the number 1 is kids protection. So why am I bringing up kids protection here? Well, in Colorado, if you don't have a permanent guardian set for your children or even your grandchildren, since we don't have the next of kin law, what happens is while that guardian is being set up, your children or your grandchildren could go to foster care. And so if you know that, it's very easy to fix that by setting up temporary guardians and things like that. So if your children have not yet put you as temporary guardians for your grandchildren, you need to let them know that that's what can happen, and to please come in or see somebody about getting that set up. And it doesn't have to happen, but that's the other thing. And then the other part about kids protection is when your child turns over 18. Once they turn 18, you send them off to college or whatnot, you can no longer make decisions for them because they're an adult. And if any of you have taken grandkids or children to the doctor when they went from 17 to 18, all of a sudden the front desk doesn't talk to you anymore, right? You don't have clearance to find out the HIPAA releases and things like that. You don't have the ability to make decisions for them. And that works for both medical and financial. So if you have single children who are 42, 50, whatever age, but they don't have a spouse, they don't have a champion, it's a good idea to get this set up because, again, as we saw in the medical powers of attorney, the way we do it in Colorado, if you don't have a next of kin picked, is they get everyone who's interested in you over the age of 18 in the hospital room and you vote on who is going to be the medical power of attorney. So if you don't want, your exes and your currents and your mistresses all in the same room voting on what they're going to do for you, you better get that set. The number 2 there, part B there, is probate. A lot of people come in because they've heard about probate or they want to know more about probate, or they want to avoid probate. And what is probate? Well, probate's the way that Colorado distributes your property to other people. And you go through probate if you do not have a will, or even if you do have a will. As we like to say, where there's a will, there's a probate. You just need to go through it, and the judge basically decides and helps you decide how things are going to be distributed. But more often, probate's about your creditors. And in our office, we define probate as a lawsuit against yourself, funded by yourself for the benefit of your creditors. Why do I say that? Well, the first thing you need to do is put the deceased person's name in the newspaper so that anyone that person thinks that person owes money to, that person can ask for that money to be paid. If you are a creditor and you wait 45 days after the person dies, you can open probate on your own. So it's really set up for the creditors, and all the creditors get paid before anything goes to your loved ones. So a lot of people want to avoid that. Probate can take a little bit of time. Probate can also cost quite a bit of money because in Colorado, you're usually paying an attorney $400 an hour, and probate can last up to at least a year and sometimes longer. So paying $400 an hour for a year even makes me shudder. So that's why a lot of people want to avoid probate, and they come in and talk to us about that. The third big reason why people come in to talk to us is that incapacity piece. And I think estate planning is mainly about incapacity. Once you pass, there's laws, or you have a will, or you can have a trust that can decide where the property goes. But the big thing and the sad thing is I see quite a bit is when someone can't make decisions for themselves, or they have someone else making the wrong decision. I had a client come to me once whose daughter was 42 years old and got in an automobile accident and had a traumatic brain injury. She went to the hospital without a medical power of attorney. Her mom flew in from out of state, wanted to take her home and take care of her. In that room, since there wasn't a medical power of attorney, there was a vote between the ex-fiance, the boss, and a coworker. Those three outvoted the mom on who got to take care of this person. And it didn't sit well with mom, as you can imagine. So we went through probate process and did a guardianship conservatorship hearing, emergency one. And about $12,000 in legal fees later, mom got to take her daughter home with her, which I submit should have happened right from the get-go if there would have been powers of attorney in place. So that was a tragic thing, and I think the $12,000 would have been better spent on the healthcare than it was on attorneys. But that was happening because it wasn't done ahead of time. So incapacity is a really good reason why we help folks work with things so they can pick people that they know, like, and trust to make their decisions for them, and to find people who are going to make decisions the same way that you would make the decisions had you had the chance, and not leave it to be appointed to a judge who you've never met, he or she, and make that decision for you. The third one is disinheriting loved ones. And that kind of comes about because if you don't have a will in place, the Colorado statutes basically say that your property, if you're married, goes to your spouse. Okay, nothing goes to your kids as long as you had those two kids together. So it just goes to the spouse. And that's just the way it goes because the legislature who put those laws in effect just assumed that the spouse would take care of their kids, which is fine. But a lot of us maybe die a little sooner than we wanted to, and we end up getting remarried. 77% of my clients get remarried. Something about being married the first time breaks you down, so you don't say no the second time, I guess. Or it's the economics of the deal where one of you has to work just to pay the taxes so the other one can feed the family. But for whatever reason, they all get married. And if you continue to not have a plan, it continues to go from spouse to spouse if you die before the other spouse. And eventually the third or fourth spouse has no relationship to your children. So you can basically end up disinheriting them if you don't have a plan in place to help them out. Lost property comes in as also one of the probate processes. It's the favorite part of the will that I like reading those, is a part of the will that says all my rest, remainder, and residue, I leave to my kids 50-50 if you have two kids, or if you have three and you don't like one. So the rest, remainder, and residue, a lot of times we're sitting around the table with the kids trying to figure out what that means. And in the old days, and when I say old days, I've been doing this since 1988, so a little while ago, but in the old days, we just would switch the mail to our office and we could find out what the person owned because there'd be bills and bank statements and things like that. Well, now it's all on your phone. Most of us won't pay the extra $5 to get the paper copy. So now we don't have access to the phone because the person who died forgot to give us the password and we're trying to figure out what rest, remainder, and residue means. Well, if you're a custodian of funds like a life insurance policy or a bank account or something like that, and you don't know where that goes, you can legally turn it over to the state of Colorado after 3 years. So you can use it, get the interest off it, make money on it for 3 years, and then legally turn it over to the state of Colorado as unclaimed property. My question is how hard are these people really looking for you when they get to use all these funds for free? But anyway, and it goes to this unclaimed property. If you look at unclaimed property now in the state of Colorado, there's over $600 million in that. And that's just people who forgot to do things. I actually got $50 in it. I went to school up in Wyoming and I had a credit union account with $50 in it to keep it open. And I didn't contact them for 3 years, so they just sent it to Colorado. Kind of made me mad because I knew I was in Colorado. Why didn't they just contact me and give me my money? But I got $50 and that's my retirement plan, so I can get that. So that's lost property. The next thing a lot of people come in to talk to us about is to protect loved ones. And protect loved ones, there is a way that you can leave property to your loved ones so that it stays in the bloodline and it won't be available to creditors and predators. Now, creditors are the people like you see those late night plaintiff's attorneys that make all attorneys look so good. Or it could be a bankruptcy court. Predators, we call those usually the spouses who want to get a divorce. But there is a way that you can leave your property once you die so that no one else can touch that. And we can, talk more about that at a later time or get you more information on that. But there is a way where, let's say that you had a house that was fully paid for, was worth $500,000. You have two kids, so they're getting $250,000 each. So you can decide to say, hey, that's enough to start my life over with. I think $250,000 would be enough. If someone took everything that my kids had in a nasty divorce or some kind of bankruptcy or a lawsuit, they could have this $250,000 I left each one of them to start their life over. And is that worth it to me to do that? And there are ways to do that. There's ways to leave that so we'll stay in the bloodline and it won't go to creditors. And then the final reasons there, a couple reasons there. A lot of people have outdated plans, so they'll come in and I already mentioned that a little bit. Dangers of those. And then trust funding is what we call it, but that's just a legal term for if you have a trust, you got to put things into trust for it to work. Because the trust doesn't work unless you put things into it. Okay, so And I always ask my clients, if we could only address one problem above, which one it'd be? You can kind of circle that one to see which one lands the hardest on you. With a lot of my younger clients, it's the first one, it's kids protection, but some people like the asset protection, those kind of things. And we just talk a little bit about what is the best way to protect those people. Okay, so let me kind of change gears right there. Those are the goals that most people come in, and if any of those goals kind of raise some issues with you, just circle that. Our emails on the bottom of that page, and you're more than welcome to ask for more information on any one of those or to come in. We'd love to talk with you about any of those things. But let's talk a little bit now about the differences between a trust and a will. I need my cup, please. I need my trust. Okay, so forgive me, I used to teach middle school. So when you own things with either a will or without a will, basically you hold all the title in your hand, right? You're holding it really, really tight. And these are all markers, but what could they be? What is your estate? Well, in Colorado, your estate is like your house, your any other rental real estate, vacation home, office building, mineral rights, timeshare, bank accounts, business entities, brokerage accounts, any of your vehicles, your personal property, all those guns you have, those little gold coins you have hidden in the coffee cans in the backyard. You know what I'm talking about. It can be your artwork, your jewelry, your furs, your furniture, your boats, your airplane. It's all that stuff. And you're holding all the title in your hands, right? And it's like, well, Matt, I really don't have a title on my couch. Well, that's probably true. But if I went to your house and started walking, well, I'd have to have two people. But we started taking your couch out the front door, you'd say, hey, that's mine. And the judge would agree. So those are all yours. And you're hanging on to them like this because they're all yours, right? And so when you die, what happens? You drop them. Now, in Colorado, if this amount of stuff that was dropped that does not have a way to get to someone, is if that's over $80,000, right? Or if it's real estate. Of course, if you have a house that's worth less than $80,000 in Colorado, I don't want to see it. But if it's over $80,000, you're going to need to go through some kind of probate. So what happens is they either your will says it or the statute says you got to find a champion. You got to find someone who's going to take your cause to the courts. And this is why wills and trusts are very important for single people, because they don't have like the spouse who has an interest to get all the property, or they don't have kids or something like that to come in and take it. So you got to get someone appointed. This usually takes 2 or 3 weeks. You get these things called letters of testamentary, which are the keys to everything. Once you have those, you can do a lot of things, but those are those are only issued during probate. But you find a champion who goes through, and they're going to come pick up all your stuff, right? And they're going to find it. And they're sitting around my table saying, what does rest, remainder, and residue means? But we're going to find it all. And you look at who it goes to, and after you pay the creditors with the court's permission, you then give that to who it belongs to. Notice I lost one, so that's going to go to unclaimed property because we couldn't find that one. So that's how a will works. Is basically you got to find who owns the title after you pass. Now, what's the difference with a trust? Well, trust is like this cup here. So what you do is you develop a trust, and you just set it up, and this thing is going to hold your property. So while you're alive and you know where everything is, you retitle everything and put it into that trust. And so you're retitling it from you as an individual to you as a trustee. This particular trust is what they call a revocable trust, which is just attorney speak for it's not really an entity in and of itself. It doesn't change your taxes. You still use your social security number for it. The IRS doesn't even care that you have a trust. It's just a way to avoid probate, basically. And how does it avoid probate? Well, now the trust owns everything, and you have a successor trustee. A successor trustee is like a second manager who manages your property when you go. It's like if you had a business, everything was owned by the business. When the business owner was gone, the second in command could take over. But that's what the trust is. And basically, when you die, you just hand it off to the trustee. You're not going through probate for a year. You're not going through the court to get another bank account set up. The trust owns everything. And you're just a signer. The bank already knows you're a signer in an account. So you're signing checks within a few days, which is very important when you're trying to maintain property and the taxes are coming due and the utilities and everything like that, and not waiting a couple months to have the court approve you. So that's the nice thing about trust. But the great thing about trust is that can also happen during your incapacity. Okay? If you're no longer allowed to sign checks, which is what the legal definition of incapacity is for estate planning. Okay, you don't have to be drooling or anything like that. It's just like every time the Prince of Dubai calls you, you send him a Walmart card. You probably shouldn't be doing the checks anymore. So that's what it is. But now your loved ones can use your property to take care of you. Okay, when you have a will, it only goes when you pass, right? So if you got a will and you're incapacitated, you're not letting go of this stuff. Because the first thing we do when we become incapacitated is we know we're losing control. We get a little stubborn, right? So it's like, so how do your loved ones pay for you if you're in that nursing home that's costing $12,000 a month? They're putting it on their credit card. And then when you die and finally let go, they're now a creditor like all the other ones in your will and in your probate. Okay, so that's a visual look at the a difference between a will and a trust. Okay, just to go into asset protection a little more. This is a revocable trust because the top's open. Why is the top open? Well, because this is a contract, and it's a contract between the grantor, which is the fancy attorney word for the person who wrote the trust, the trustee, which is a fancy attorney word for the person who manages the trust on behalf of the grantor, and they do it for the beneficiaries. And while you're alive and you have capacity, you're all three of those. So you have a contract between me, myself, and I. So it's like, hey, self, can I take stuff out of this? Oh, sure, right? That's a contract. Well, once you pass, what happens is another trustee takes over. You don't have that agreement between three people because the grantor has now died. And that just basically puts a trustee on top of this who gives permission to the person to take things out. It's like, hey, Uncle Bob, can I buy a Ferrari? No. Can I go to school? Yes. Can I marry Bubbles? No. That's what gets the asset protection. And when you have the top on it, that's what turns it into irrevocable trust. Okay. It's just basically that trustee needing to get permission. So that's how you can get those to work. But that's the difference between wills and trusts.
So, may I
You have some questions?
ask a question?
Mm-hmm.
So, as a lawyer, would you say we have a trust? You know, we have will, but do you think it is good idea to have a trust?
The question was, do I think it's a good idea to have a trust? And you know, just for total, disclosure, trust costs a little more than a will. Okay, but you do get a void probate, which is you pay up front instead of at the end. So I just want to get that out there. But yeah, I agree because of the incapacity piece. I think the trusts are superior. Let's go ahead and do I have like 10 minutes?
10 minutes.
Okay, let's go ahead and just let me tell you what I recommend here at the end there for the top 10 recommendations for a comprehensive plan, and then we can talk a little bit about more for that. So at the end there, number 4, this is what I recommend for a comprehensive estate plan. What I've done for myself and I've done for a lot of my clients. So first of all, I do recommend a trust because I don't like probate. Okay, I've had a lot of problems with probate. I've had some that are about they're going on their 15th year to get it done. But that it's unusual circumstances. We had 4 people on the property, the real estate. 3 are dead, and the 4th one's in jail. So it's a case that keeps on giving. I also believe in a kids protection plan, which is number 2, and that's whether they're under 18 or over 18. I just think that there's nothing worse for a parent to not be able to help their children, regardless of their age. So we're really adamant on that. And we've talked a little bit about that in these series before. That's mainly that medical power of attorney. To help with a lot of those, make sure that you have the ability to either make decisions for them or you have someone who can make decisions for them. C is the pour over will. So with a trust, you still have a will, but it's a pour over will. And for the people online, it's POUR, not POOR. But a pour over will says if we forgot to put everything into our trust, it just takes that and pours it into the trust. Okay, so it's a safety net. A lot of times, if you have everything in the trust, you won't ever have to do the probate or anything like that. And remember the 80,000 figure. If you have less than 80,000 figure outside of the trust, you would just get poured in there with what's called a small estate affidavit, which we can talk about in a little bit here too. Fourth thing there is durable financial power of attorney. So we haven't talked about that in this series yet, but we got the medical power of attorney, and that's the agent who makes medical decisions for you. The financial power of attorney is the one who makes decisions for you, and that can either be, you can either set it up that they can make decisions for you immediately or only until you've been proved to be incapacitated, which is typically a physician or a licensed psychologist who can make that decision. Again, you shouldn't be writing checks. But you need the financial part because there's two parts of our lives. There's one where they're making decisions medically and, kind of lifestyle. And then the other one is the purse strings, the financial one. So you definitely need a financial power of attorney. And those need to have certain things in it other than the one that they let you have statutory. You should have a few things in it, like allow people to get into your digital assets, allow your agent to talk to government officials in case you had a healthcare, long-term healthcare type of deal where you needed to work with Medicaid and things like that. But those are very important to have a durable financial power of attorney. If you have a trust, everything that's in the trust will be handled by the trust, even during your incapacity. So the financial durable power of attorney is not as important. If you have a will, the financial durable power of attorney is the only way that your agent's going to be able to take care of you if you're incapacitated. Please note that the trustee has a fiduciary duty to do the right thing, where the agent in a financial power of attorney can make that whatever mistake you could make as an agent. So that's the difference there. And a lot of times banks will take a trust a little more readily than they'll take a financial power of attorney. Personal property memorandum, very important. I've seen millions of dollars pass, and that was fine, but it was the personal property that made the family not have any more reunions or barbecues or things like that. I was at one funeral where all the kids skipped and went to the house to switch the Post-it notes on the furniture. So, that will derail things quicker than anything. So just make sure if you have an item you want to give to somebody that you have either a trust or will that allow you to give that to them. And then all the rest, remainder and residue, can go however. The healthcare power of attorney, we've talked quite a bit about that. You guys have a one that was handed out. Again, when you're incapacitated, you might want to add some provisions in there, like please keep me in my home as long as possible. If the pain medicine is making me feel good, but it's speeding up my demise, it's okay. I'd rather feel good and then live a long time. You can add to the medical powers of attorney quite a bit so people know what to do, including allowing your agent to take you out of state if Colorado's not doing what you want them to do. The advance directive, which is a living will, it's called a living will. Notice it has no relationship to the last will and testament. The living will just says what's going to happen to you if you're in a persistent vegetative state or terminal condition. How many days do you want to stay on life support and or artificial nutrition and hydration? HIPAA releases, those are the ones that allow people to know about you, but they can't make decisions. So you may have an agent that you want to make all your decisions, but you may have other relatives who you want to give the right to call the hospital, find out how you're doing, but they can't touch you. Memorial instructions. I gave you an example of that on the back of the page I gave you, just a real simple one. Again, the money can usually find its way where it's supposed to go, But if you don't know what happens when, how you want the person to be taken care of, that's really hard on the family.
Questions.
Okay, so, and then the last, thereafter the memorial instruction is the certificate of trust. And this is a document that's in 2 pages. It tells everybody who has your money that you have a trust, so you don't have to show them what's in the trust. Because a trust is private, a will is not private. So we know a will is not private because we can look up online and find out that Jackie Onassis gave somebody by the name of Bunny Ferguson $375,000. Why do I know that? Because she had a will. Where Walter Payton, when he died, had a buddy in Chicago doing his trust, and the sports desk called and said, we want to know where Walter left all his money. And the attorney said, well, I don't have to tell you because it's in a trust. And the sports editor said, well, we'll see about that. Never called back. So trust them all private. So those are my recommendations. Like I say, I'd love to talk to you more about this. If you just let me know, and I'll open it up for questions.
Our son is going to be getting married this summer, and
Congratulations.
they talked about having prenuptial agreements, but they've not done it yet. And so if they don't get it done, is there anything that we can do with trusts that would help there?
With their money or your money?
Our money?
Okay, so the question was having a marriage, and we like to call those marital agreements now. The prenuptial's got kind of a stigma, but kids may not get around to marital agreements, which is quite common. Well, don't you love me? And can we protect what we're leaving them? And the answer is yes, you can. And the best way to do that is through a trust. Now, a trust you can either start with a trust that turns irrevocable, or you can start with a will that asks the judge to set the trust up for you. But either way, you want to get a trustee on there, which can be your son, right? Your son can be the own trustee, but what happens is he's got to get permission for that money. And so it stays in the bloodline because it doesn't go to the spouse. It's never really available. It's separate. You can also put Uncle Bob or whoever as another trustee on there. And in our trust, when we're asked to, we'll write the requirement of a prenuptial agreement. So if anyone ever gets remarried, the new spouse has to admit that that's not their money to get remarried. And it's more of a loving way to ask for a prenup, because it's like, well, don't you love me? Oh, I do, but I'm going to have to give up all this money if you don't sign it. Oh, okay. And I'd like to buy you a new dress. Okay, I'll sign it. So yes, absolutely. And that's one of the main reasons people do that, is because for some reason, some parents don't like the spouse as well as their kids do.
I've got a question from Zoom.
Mm-hmm.
If all assets and liabilities are in both spouses' name, would there still be probate if something wasn't covered in the will?
So yeah, so joint tenancy, which we didn't get time to talk about, but joint tenancy. So the question is, unless you marry or you have joint tenancy with a spouse or a person that's immortal, there's going to eventually be a probate. You can move it down the line a little bit, but if both spouses own it and they're on a trip and the pickle truck hits them both, that's a probate. So that's a danger with joint tenancy, is that you're looking at it and you're saying, okay, I'm going to die in this order, and I'm going to die first. Some people do it with their kids, and I'm always looking at them in amazement, because they're in an assisted living where they have these little things where they can pull if they hurt, and they get 3 square meals and they don't have to go anywhere, and people are taking care of them, and they're going to die first, and their kids are going up and down I-25 to come visit them. It's like, maybe not. So it can delay probate, but it won't get rid of probate.
Thank you.
We're at about time, and fortunately, Matt has offered his email for further questions that you might have and reaching out to them. Thank you so much for being with us today.
Absolutely. You want a book for your library?
This is the best estate planning book, Matt said.
It's a bestseller. I'll leave it for your library.
Wear clean underwear.
Wear clean underwear.
My mother always said.
Yeah, if we know some people have to leave, I'll scoot over from here. Thanks. We know some people have to leave, so if you have to, go ahead, but we just wanted to kind of wrap up our wonderful hour of talking about the things we've inherited, the things that we want to leave behind and protect, and all the ways we want to leave a legacy for those we love. Just, I've been thinking about what are those intangible things as well. And for me, one of those things are prayers, songs, rituals, the things that get passed along to us spiritually, emotionally, that aren't tangible, but are very much part of that legacy. And I also wanted to share one of my best spiritual practices when I need a little inertia and I'm having trouble finding a spiritual practice is to turn to chants or songs. So I wanted to share one of my favorite ones that we'll play, and it's one that I intend to pass on to our son, hopefully around the campfire at some point. So our encouragement is to be thinking about those intangibles too, that we pass on as part of our legacy. We don't know what the linking objects are going to be that our loved ones will attach to, but we can kind of infuse some gifts of different types of treasures into what we leave behind. So this is called the Mother's Response, and it comes from the Kohenet Jewish community, sung by Riv Shapiro, and it's one of my favorites to kind of ground myself. So we'll kind of close with this.
And we leave in silence after this.
And then leave in silence.